We've got this fight in Florida about whether the government, whether cops can search your car, search your person when they smell marijuana, right? I've been doing this for 31 years here in Central Florida. If a cop smells weed, that's evidence that there's a crime afoot. When a cop smells a potential crime, they get to do a search to try to find that evidence of that crime, that being the weed. Your whole car gets searched, your whole person gets searched because the officer smells weed coming from your car. Except that in one district court of appeal in Florida out of 6, the Fifth District Court of Appeal, in the Baxter case, which I've done a video about, the court said, no more. No way are we letting the cops search your car and search your person because they smell weed, because we have determined that it is no longer evidence of criminal conduct. It can be evidence that you just have a medical card. It can be evidence that you were smoking hemp or that you have some hemp around. And therefore, with all these potentially legal explanations as to why the cop is smelling marijuana, we can't let the government just search everything and search everyone like we used to. That's Baxter. Along comes Leggett, another 5th District Court of Appeal case. And Leggett is sentenced to 30 years in prison as a habitual felony offender for having a bunch of drugs in his car and a firearm. And Leggett got his 30 years. Why? Because the officer smelled weed, and after smelling weed, said, look, I got to search everything, and found everything, and now Leggett's got a 30-year sentence. Leggett appeals and says what we talked about in Baxter. Hey, court, what about the Baxter case? I'm in the 5th District Court of Appeal. Just like Baxter, Baxter got his stuff suppressed because in the Baxter decision, you guys determined that these cops can no longer say with certainty that a crime was committed when they smell weed. These cops might be smelling medical marijuana, or they might be smelling perfectly legal hemp. We can't let them search anymore. And the 5th District under Baxter said, we can't have this anymore. But the problem in Leggett, court said on appeal, Leggett relies heavily on this court's recent opinion in Baxter v. State of Florida, where we concluded that the odor of cannabis alone can no longer be the sole basis supporting reasonable suspicion for an investigatory detention. While Leggett's reliance on this appeal on Baxter is reasonable, the caveat in Baxter remains true here. Because the deputy in Leggett reasonably relied on binding precedent at the time of the arrest, which was not Baxter, by the way, this search comes within the good faith exception and is not properly subject to the exclusionary rule based on Davis versus the United States. Leggett got searched a year before the Baxter decision came down. So the cop that searched Leggett and led to Leggett's 30-year prison sentence didn't know about Baxter because Baxter wasn't written and Baxter wasn't ruled on when this cop did the search. And therefore, the court in Leggett's like, no, you got to do your 30 years. So we're starting to see some things funnel through the system, folks. My hope is that more district courts of appeal are going to side with Baxter in the 5th DCA and decide that we have to put an end to citizens being searched because a cop smells what could be hemp and what could be medical marijuana. We need to stop this. But in the Leggett case, they're like, your case is a little too old. If something happened to you in Central Florida, give us a call because you know we're going to be able to help you. We've been helping thousands of people for 31 years. If you're not in trouble, the vast majority of you aren't. I just appreciate you watching. I hope you'll hit something on your screen that will help us out because everything you hit, it's positive, actually helps us. Thank you in advance. Have a great day.